Honorable, the Supreme Court.
All right, thank you. Good morning, everybody. Good morning. Thank you. Please be seated. And go ahead, call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Jennifer Knapp Dasler versus Timothy Dasler, case number 23 AP 408. Appellant Timothy Dasler is self-represented. Representing the appellee, Jennifer Knapp, is John Loftus.
Thanks very much. And before we start, let me just alert both of you that we've had some problems yesterday with wasps in the courtroom. I just in case either one of you have any problem, either when you're at the podium or at your desk, just let us know and we'll take a recess and try to figure out how to take care of it. We considered handing out fly swatters, but we don't have any, so that's off the table. So having said that, Mr. Dasler, come on up. And you understand, sir, you've got 15 minutes and hopefully there'll be an alert for you with the light going on, blinking and yeah. And then with that understanding, please go ahead with your argument.
Good morning, Your Honors. The issue before us is improper application of the abusive litigation statute, section 1181 through 85, which went into effect September 1st, I believe, of 2023. The Windsor Court unconstitutionally applied it retroactively, relying on filings predating the statute, and without something post-stating the statute, all that's left is retroactive. The only relevance of a filing predating the statute is whether or not something post-stating the statute is relitigating it. What we're left with instead is Ms. Knapp's allegation is that somewhere in the last 6 years and 118 pages of filing, something was abusive, but we're not going to specify, just sort of the conclusion. And what was requested is dismiss everything pending with prejudice. And that includes at the time, my pending motion for enforcement, where John Loftus had submitted a false copy of Exhibit 13. It was meant to be the child's entire medical records. He withheld 90 pages, everything post-dating the divorce that was relevant.
Hasn't that been litigated?
It was, and I prevailed. But my point is, his request was to dismiss everything, including this indisputably valid litigation. And what the court did is it just dismissed everything that was still pending. The point is, I prevailed. He submitted a false copy. He did not include the 90 pages. He read into the record.
Yes, Mr. Dasler, I don't know about false copies.
Yeah.
We're not going to talk about that here.
Well,
Focus on your appeal issues. What you have appealed is a decision of the trial court on December 4, 2023. Is that?
This is relevant, yeah.
All right.
Yeah.
And let me just advise you something else too. We don't engage in personal attack here. That is not the purpose of this proceeding. You understand?
Yeah, I do.
So I'm not going to tolerate you talking about a counsel for the appellee, and I say the same thing to him.
Yeah.
You don't get away with making personal attacks. He lied, he filed false. I don't want to hear it. We're not going to listen to that.
Sure.
You've got to stick to the issues and the law. That's what we want to hear.
Yeah, and so that's an issue that I prevailed on. And then the pending issue, this order dealt with several things. There was a contempt issue. The contempt on that same enforcement issue was separated. They weren't handled on the same day. So the contempt related to the the copy excluded 90 pages of the exhibit. And that's just a fact of the case. And the way that exhibit was handled in the hearing was it was read into the record. It was represented as something that it was not. It included letters from the pediatrician that Ms. Knapp had asked her to write, and it was represented as though this is just part of the medical records.
Right.
So the problem here is when we're talking about whether or not contempt was appropriate, whether or not my pending filing at the time was appropriate, what I'm saying is what was before the court and what was asked to be dismissed was eminently reasonable. Now, you could argue whether or not it was intentional, but once I pointed it out to John Loftus, I asked him to give me a copy of it. He didn't produce it. I filed eventually a motion to enforce. He still eventually admitted that he didn't produce to the court this complete exhibit. It wasn't filed correctly. And then still didn't correct it. It took months, it took litigation. I filed a motion for summary judgment, which was pending at the time of his filing for abusive litigation. And that summary judgment, again, was eminently reasonable. I was saying there's no factual dispute here. He's already admitted what was submitted was not correct. It didn't include 90 pages. I'm asking at minimum in enforcement, we don't need a hearing, let's just correct this copy. But instead, what's happening is there's generating more litigation. It's requiring a hearing that shouldn't have needed to happen. And I'm trying to say, can't we just avoid this? But in the broader scope of this, the point here is not to say, I'm not trying to just malign another party. The question here is, my argument that this is a contempt issue has to be in context of the broader issue that this wasn't an isolated incident. In that same hearing, I filed a motion. We had both agreed to, when I say that same hearing, the 2022 hearing where the Exhibit 13 is in question. My argument is that this is part of a broader pattern of misconduct, which included, I asked, non-party counsel had asked to reschedule a deposition. I agreed. I didn't want to have to fight over it. We all agreed. And then when I asked for a continuance, John Loftus told the court that this is for a federal case, that this deposition is for something else entirely. But my response there again, when he lies to the court, and I don't mean to say it, literally.
No, I mean, that's a word I just don't like.
Okay, let me rephrase it.
I'm sorry, but find another way to characterize it.
Okay. Please. He has the entire email chain. He has the subpoena with the case number. He has the emails between non-party counsel and my counsel. He agreed to reschedule it. He has all of that information. And the claim that it's for a federal case has absolutely no basis whatsoever. But telling the court that was to prevent a continuance. And the court granted that on the same day. I filed a response asking the court to reconsider on the basis I could not have responded to his representation, which, you know, by all of our communications, we had agreed to this reschedule. The point is, there is a whole chain of things that I think are really indefensible. And me asking for a contempt motion isn't just out of the blue. It's not an isolated thing. It's not just one thing. It's a pattern of things.
But
And then-
Mr. Dasler, isn't your request here to say that the trial court abused its discretion or made a mistake when it issued this abusive litigation order against you?
Yeah.
Isn't that what you're arguing?
Well, right. And so what I'm saying is this filing we're talking about now, that is the only thing that was really pending before the court that was allegedly abusive. And the notion of dismissing that with prejudice, which is what the court did in the abusive litigation, is essentially to say, like, oh, well, we're not going to consider, we're not actually going to consider, we're going to dismiss it as though it's abusive because somewhere in the past, before the statute existed, there was something abusive. What the court didn't do is identify what's abusive. And what that has to mean is no basis, right? I mean, it's not enough for there to be an arguable basis that the court disagrees with. And let me give another example because the court relied upon past orders. If we're going to talk about 118 filings, you can't give me a 30-minute hearing and say, well, we'll figure out at trial what we're talking about. We have to have enough time to lay the basis for that. Well, however many of those filings we're going to be talking about, we have to identify them. We have to have more than a conclusory allegation. And that wasn't what was allowed at the hearing. I had 30 minutes to on the fly figure out, like, well, I'm not sure what we're talking about today, but we'll figure it out. But really, this also highlights why we can't go into the past and reopen closed things. It's just like with sanctions. Like you have to litigate it when it's before the court, not reach back indefinitely to say, well, now let's just pick through everything and open it all back up. But when we look at some of what the court relied upon, we see things like courts saying that I didn't have basis for a Rule 59 motion. If we look at Judge Gray, her handling of one of those, for example, in July 2022, I filed a motion to enforce visitation. She ordered parent coordination instead. I filed a motion to reconsider saying, I can't afford the fees. It's just too much. And Judge Gray didn't acknowledge that argument. She said, well, he's unreasonably asking for attorney fees. And I filed a second motion to reconsider, thinking she just didn't understand. And I said, the court says I don't have an attorney, but I do. I have limited scope attorney. But second of all, I'm saying I can't afford to comply. And the court said, again, he gives no basis. On the same day that Judge Gray says he gives no basis to reconsider, that's December 20th, 2022, she files an order denying opposing counsel's motion to enforce parent coordination because she says, father says he can't afford it, therefore the court is without authority to order it. Now, if we're going to look at Judge Gray saying he filed 2 motions to reconsider with no basis, we have to also look at the fact that she knows she didn't have authority. And it's really troubling for me. I know we don't want to talk about, I don't know what to call something like that. When a judge.
No, don't get personal.
No, I'm not trying to.
Don't do it. I'm going to hold you out of order. I'm telling you right now.
I'm trying to say, when these 2 orders say different things, I'm now being accused of making this unreasonable filing. But I don't know what to do with that when now subsequently a new statute comes online. How am I supposed to address this thing that I don't know how I'm supposed to go back and deal with that. The standard for abusive litigation has to be no basis at all. And clearly there was a basis, otherwise she would have enforced the parental coordination order. I mean, I'm not sure how to address an issue like that, but this is, again, why we have to have a pending filing, why we have to address them when they're pending. We can't go back and say things that were already resolved sometime before the statute existed were allegedly abusive. But it's also one of the many reasons why the underlying RFA needs to be available for collateral attack. In 2017, when that hearing was held, I did not have the incentive to litigate because there wasn't this existing legal context. I was compelled to choose between 14th and 5th Amendment rights. And the landscape there is particularly problematic because if I prove my innocence 100%, it doesn't mean I get my rights back. I mean, we see cases like Knudsen v. Segalis where no credible factual basis to the allegations was not enough to restore the rights of the accused. So my incentive to litigate that time when I'm facing a pending criminal charge is not really there. But also, I didn't have the evidence. We were doing a criminal investigation. I couldn't get my public defender to investigate. It took more than a year to get the evidence that we now have. So if we're going to go back and revisit the RFA or try to bring it into a new legal context, I no longer have my hands tied behind my back trying to choose between 14th and 5th Amendment rights, where immunity is not available because she's working directly with the prosecutor. A stay is of no use when a temporary order can be used against me, regardless of whether or not the accusations have any basis. So there's really no incentive at all. All it does is prejudice my case. And the court in the abusive litigation order said that essentially I pled out to the charges, which is also not true. I pled no contest to a charge of disturbing the peace, and disturbing the peace is not covered at all by an abusive litigation. But again, we're running into this thing where the court is sort of grasping at straws to justify somehow creating a basis that I just don't think is even vaguely reasonable. And this statute's not designed to tie a party's hands behind their back. And if we look at what is permissible, what is abusive, we have to also consider what has happened in this case. I mean, Ms. Knapp, in fighting the 50-50 visitation order, filed 7 motions totaling 170 pages, dragged it out for months. And the court said, well, she subjectively believed in the allegations, even though the court didn't find them founded. So if that's the bar, 175 pages to fight one order, I mean, that's a tremendous amount of litigation on one issue. Nothing that I'm even accused of even approaches that kind of thing. But also, when we look at 118 filings, we have to also say, nothing in the statute says you just tally up the number of findings and say that that counts as abusive. I mean, a lot of that is me responding to Ms. Tina and a whole series of things. I mean, she filed, what, I think it's at least 6 motions trying to obstruct my subpoena of medical records that I'm legally entitled to without a subpoena. So we can't just count up everything without, just indiscriminately. But also, if I go back to that RFA for a minute, there's a big problem with a litigant being able to shift the legal landscape dramatically by simply severing contact on an ex parte basis. And I know I've been before the Rocket Docket a number of times. Challenging precedent is not available there. And so I feel like it's sort of problematic where.
Well, I'm not so sure challenging precedent is not available.
Okay.
I'm not sure I agree with you about that, but I understand
Okay.
there are, certain realities of that docket too.
Yeah. Well, yeah. And I think when we look at sort of this bigger.
Your light's on, so can you wrap it up, please?
Sure. I guess there's a bigger problem, I think, with shifting the legal landscape. And then, we look at concurring opinions in Cabot v. Cabot and Knudsen v. Segalos 2016 and 17, saying the kind of spiral that the non-custodial parent is fighting against and how hard that is. And that's essentially what I'm touching on here and how that affects the legal landscape and what I'm up against.
Thanks very much. Okay. We'll hear from counsel for the appellee. Please introduce yourself, identify your client.
Yes. Good morning. My name is Tom Optis. I represent the appellee, Jennifer Knapp. In my review of the briefs in this case and hearing what I've heard this morning, I guess my position is that there was a proper application of 15 VSA 1181. I think it was interpreted correctly by the lower court. The facts were applied correctly. And beyond that, I would rest on my brief. I'm more than happy to answer any questions.
Okay. See any hands? Thank you very much.
Thank you.
Thank you, Eddie. Is there any time for the appellant left?
There's no time remaining. But the appellant has no time remaining.
No time. Okay. Thank you. Please call the conclusion of the hearing.
The next hearing for the court is scheduled for 1:30.